matter of Owen and Black Horse Ltd.
Yes, Mr. Butters. Now we have the morning for this appeal. We're listed half a day. Do you think we're going to finish the argument in before lunch?
I would very much hope so, my lord, yes.
Okay, all right. Well, we've read I think the salient documents, the judgments, the very helpful and full schedule arguments. And I don't think we need to bother ourselves with the facts of this particular litigation.
My lord, no.
Save an outline. It's really, the question is an interpretation of the rules.
My lord, absolutely.
And I think that's, we for our part, we think that's where the argument is probably going to focus.
I'm grateful. And, my lords, before I go further, it's my learned friend, Mr. Neville, for
yes.
the defendant. The issue before the court is one of interpretation of CPR 27.9(2) and the jurisdiction to strike out on non-attendance of the claimant at trial. There is no separate ground of appeal in relation to the DDJ's exercise of discretion. And I would just like to make one point at the outset, which really follows the earlier observations of the court. For our part, to make clear, we completely reject the view of the DDJ and the defendant that this is a claim that ought to fail on its merits. That issue obviously doesn't arise on this appeal. I did make reference to various cases at footnote 2 of my skeleton argument in support of our argument on the merits, because the defendant had, at an earlier stage, argued that this was an arid ground of appeal because the claim was doomed to fail. So I just wanted to make clear to the court that we absolutely do not accept that, but of course it's irrelevant for the purpose of today. We're solely concerned with whether the DDJ had jurisdiction to strike out the claim in the personal absence of the claimant, but with his solicitor, Mr. Durkin, attending on his behalf. My lords, my lady, I pursue 4 points under the single ground of appeal. There is some overlap between them, not least in respect of the cases of Rouse and Freeman and Falmouth Housing and Abdu Hamdan, and I'll try to take those cases in one go. The 4 headings are: first, the natural meaning of the words claimant does not attend the hearing in their context refers to non-attendance by both the claimant personally and any representative of his. Secondly,
just a moment. So that means non-attendance by either claimant or legal representative. Right? Yes.
my lord, no. It requires both the claimant.
That's what I meant to say.
Yes.
Let's be clear. So it requires. Well, say it again exactly how you want to put it.
Both the absence of the claimant and the absence of any representative of his. No one there at all.
I said means non-attendance. So you say it requires the absence of. Okay. Maybe there's a difference. Yes?
Secondly, those words should be construed consistently with the interpretation given to the same words in CPR 39.3 1b by the High Court. Thirdly, a purposive approach supports the claimant's interpretation. And fourthly, the words used in CPR 2711 do not dictate a different interpretation. I'll start with the natural meaning of the words in their context, and I'll begin with a case referred to by my learned friend, Dover and Finsbury Food Group. That's at tab 18 in the authorities bundle, and I'm going into it at page 228. This is the judgment of Lambert J. in the High Court, and at paragraph 19, at the top between A and B, you'll see he cites...
She, I think.
She, my apologies. She cites Pinner and Everett, judgment of Lord Reed.
Sorry, forgive me, which paragraph number?
It's at the very top, so it's the continuation of paragraph 19, my lord.
Thank you.
Lord Reed observed, in determining the meaning of any word or phrase in a statute, the first question to ask, always, is what is the natural and ordinary meaning of that word or phrase in its context in the statute. And that was a case in the context of interpreting the CPR. And I entirely agree with my learned friend, that's the approach to be taken to the interpretation of the CPR. Note reference to word or phrase, and of course it may well be a phrase, not an isolated word, that falls to be construed. And secondly, on Dover and Finsbury Food Group, at the bottom of paragraph 19, just above D, there's a quote from Viscount Simons in Attorney General and Prince Ernest. Words, and particularly general words, cannot be read in isolation. Their colour and content are derived from their context. And we say just so in the context of interpreting CPR 27.9. My lords, my lady, in terms of references to the CPR, I can take you to pages in the White Book or pages in the authorities bundle, whatever is most...
Well, we've got, I think, all the rules in the authorities bundles, so
Yes.
I think let's unless there's anything particular you want to refer to in the White Book, let's stick with what we've got, shall we?
Yes, very well. So it's tab 6, page 32. And this is rule 27.9. The relevant rule is 27.9.2. And you'll see the opening words, if a claimant does not, and then A, attend the hearing. And we say the words, claimant does not attend the hearing, should be interpreted together. This is not a case that turns, as my learned friend would have it, on the interpretation only of the word attend. It's not in dispute what attend means for the purpose of a court hearing. You're in court, you're on the telephone line, you're on the video link. The question that arises on this appeal is who is doing or not doing the attending for the purpose of the rule. And in my submission, the words claimant, attend, and hearing give colour to the other. So that the natural and ordinary meaning of the words claimant does not attend the hearing obviously refers to non-attendance by both the claimant and any representative. And that's because, as we know, representatives can and do attend at court hearings, including trials, to act on behalf of parties, claimant and defendant.
Are you going to say anything about the note immediately above that on page 32?
I will,
Okay.
my lord. I was going to take that later in my submissions.
Fine. Okay, thank you.
I'll make good my submission as to the natural and ordinary meaning of the words in their context by reference to the judgments of Nugee J and Gross J, as they then were in Falmouth Housing and Abu Hamdan and Rouse and Freeman. But I'll address those cases under my second heading in respect of the interpretation of CPR 39.31b, because those were cases concerned with 39.3, which is the equivalent rule on the fast or multi-track. What I would say at this juncture is I absolutely accept that there are other contexts in which it is obvious that the use of the word claimant or party or defendant is a reference to the party personally. It entirely depends on the context. Consider an order that the claimant do attend for cross-examination, which would be an order further to the court's powers under CPR 33.4. That is obviously a reference to the claimant personally.
Would you mind giving the rule number again there?
That's
please?
CPR 33.4, my lord.
Thank you.
My next point under this heading is that the entire CPR 27.9 is drafted on the basis that party, claimant and defendant includes reference to legal representatives. So we can begin at 27.91, which you may still have open. It's tab 6, page 32. And the rule begins, if a party who does not attend a final hearing. That is materially identical wording to the wording of 27.9.2a, which is claimant does not attend at the hearing, and party obviously simply means claimant or defendant. If we then go to 27.9.1a, you'll see has given written notice to the court and the other party at least 7 days before the hearing date that he will not attend. And then B, has served on the other party at least 7 days before the hearing date any other documents which he has filed with the court. Subparagraphs A and B obviously anticipate that a legal representative may do the giving of the notice or the serving or filing of the documents on behalf of the party. You wouldn't say that the provisions of 27.9.1a or b were not complied with because the notice was given or the documents served or filed by the representative, not the party personally. That tells us that party, in the opening words of 27.9.1, must include reference to both the party personally and the party's representative. When we get to 27.9.2 and consider 27.9.2b, if a claimant does not attend the hearing and B, give the notice referred to in paragraph 1. Well, as I've already said, party, hence claimant, if it's a claimant serving the notice, is a reference to party and legal representatives for the purpose of 27.9.1, and must also, therefore, be a reference for the purpose of 27.9.2b. And then if you read 2792 as a whole, the word claimant is only used once. It's a complete sentence if you remove A and B, if a claimant does not attend the hearing and give the notice referred to in paragraph 1. Well, claimant, in the opening words of subpara 2, cannot mean two different things. It can't mean claimant personally for the purpose of attend, and then claimant or legal representative for the purpose of giving the notice. In my submission, that establishes, by reference to 27.9, that claimant in 27.9.2 must refer to both claimant personally and the claimant's legal representative. My lords, my lady, the same applies to 27.9.3 and 27.9.4, as the case may be, where reference is made to defendant or parties. I'll move on now to my second.
If attend means personally attend, is there anything illogical in the way 27.9 is drafted? If we read the word personally into every point where the word attend appears, is there anything illogical in the drafting? Or inconsistent?
My lord, if the approach is taken that this is about defining the word attend, so that attend means personally attend, then the answer would be no.
Yes. Right. In other words, if we read the word personally in 27.2, but immediately after A and before the word attend,
yes,
and similarly throughout the rule, then there's nothing inconsistent.
Well, I confine myself at the moment to 27.9, and I would accept that.
Okay, fine. I'm not saying that's a decisive point against you, but just so that I'm clear.
No, of course, our point is, in order to make the rule operate as the defendant submits, it is necessary to construe attend as meaning personally attend, and in my submission there is no warrant for doing that, which I'll come on to.
Yeah.
So my second heading, the words should be construed consistently with the interpretation of CPR 39.31b. We're still on 27.9, I think, in the authorities bundle. And you'll recall the words of 27.9.2. If a claimant does not attend the hearing, we can skip over, for these purposes, subpara B. It's accepted that no valid notice was served in this case. So it's, if a claimant does not attend the hearing, the court may strike out the claim. If we move then to 39.3, which is at tab 9, page 67 in the authorities bundle, you'll see there, heading failure to attend the trial, and then sub 1, the court may proceed with a trial in the absence of a party, but B, if the claimant does not attend, it may strike out his claim. That is materially identical wording for 27.9.2, save for the interposition of the notice regime on the small claims track. In Rouse and Freeman and Falmouth Housing and Abu Hamdan, the High Court addressed the wording in CPR 39.3.1b, and in my submission, they gave clear dicta, which respectfully this court should approve and adopt. And it's notable that the defendant does not seek to challenge Rouse and Freeman, Falmouth Housing and Abu Hamdan insofar as it construes 39.3.1b. It simply says a different interpretation should be given to the same words in 27.9.2. These cases set out the familiar backdrop to and general principles around attendance, evidence and representation at civil trials, and that informs the natural meaning of the words. So there is some overlap with my first heading, and the dicta also overlaps to some degree with the purposive heading, my third heading. Turning first to Rouse and Freeman, that was a claim where the claimant did not personally attend trial, but his legal representatives did. The circuit judge at first instance struck out the claim further to 39.3.1b, which decision was overturned by Gross J on appeal. And if you go to tab 11, page 85, you'll see at the bottom paragraph 15 of the judgment in Rouse. In which Gross J says, beginning on the second line, as to the construction of CPR 39.3.1, giving the words their natural meaning, I cannot agree that a party does not attend when its legal representatives are present at the trial. To my mind, in that situation, a party is present, as Mr. Vickery submitted, by or through its legal representative. He then went on at paragraph 16 to say, put quite simply, there are a great many situations where the personal attendance of the party is irrelevant or most unlikely. On analysis, a party's personal attendance is only or principally likely to be of relevance, apart from the question of giving instructions, where that party is to give evidence. And if that is right, then a remedy of strikeout seems inappropriate. So, para 15 is the ratio of the case, and 39.1.3b is interpreted there in the face of an identical argument being pursued by the defendant as referring to attendance by the claimant or his legal representatives. And then paragraph 16 sets out the familiar backdrop to how civil trials operate, which informs the natural meaning of the words. Pausing there, nothing turns in my submission on Gross J's noting of the argument pursued by the defendant that were Gross J to adopt the interpretation he did of 39.3.1b, that would create an inconsistency with 27.9.2.
Why not? Why doesn't it? Does that help us at all? What Mr. Justice Gross says about that comparison?
No. But I'm, in a sense, heading it off at the pass. All he's doing there is paragraph 22, is noting the argument and saying, well, if the defendant's right, there would be an inconsistency. It doesn't determine the issue. And of course, it stands to reason that if the defendant here is correct, there would be an inconsistency. The defendant not challenging Rouse in terms of interpretation of 39.3.1b. NUGJ expresses agreement with Rouse in Falmouth Housing, but he first set out the general principles applicable to attendance and representation at civil trials. This was a case where the judge at first instance had exercised the power to require the personal attendance of the defendant at trial on an unless basis, If we turn to tab 16, page 154, paragraph 4 at the bottom, there are two features of the way in which civil litigation is conducted in this country I would have thought were established and uncontroversial. The first is that although an individual who is a party to litigation has a right to appear in person and represent himself at trial, he goes on to say he or she also has a right to appear by counsel.
Strictly speaking, I think this paragraph's overture, isn't it? Because the decision turned on an order that had been made by His Honour Judge Mitchell.
It is, my lady, yes.
Lords, I'm sorry to interrupt. I will be suggesting to the court that the judgment in Rouse was incorrect. It's evidently from my skeleton. It's not my primary.
Thank you. Yes.
It's not my primary submission.
Yes, Mr. Butters.
We then get to the bottom of paragraph 4. I am not aware of any principle which would prevent a litigant from appearing by counsel, nor am I aware of any general requirement for a litigant who appears by counsel to be himself physically present in court. At many hearings, this is entirely unnecessary. And then at paragraph 5, he identifies his second principle. A party is in general entitled to form their own view whether to give evidence or not. A claimant is not obliged to give evidence if he can make out his case by some other evidence or by admission. And this is all straightforward, common sense stuff in my submission. Paragraph 6, he makes the point that the defendant was free to instruct counsel to appear on his behalf and not himself to give evidence. And he goes on to say, that is from the middle of paragraph 6, and if that is the course he proposes to adopt, there would equally seem on the face of it no reason why the defendant should have to attend court in person. If he is neither going to be representing himself nor giving evidence, there is no obvious purpose served in requiring him to attend personally in order to sit at the back of court. I'm just going to take you to paragraph 40 in Falmouth Housing and paragraph 41 before leaving that case. But as I said, those principles are common sense and straightforward and inform the natural meaning of the words in both 39.3 and 27.9.2. Paragraph 40 tells us that in the present case, the Mitchell order, that's His Honour Judge Mitchell that my lady referred to earlier, required Mr. Abu Hamdan to attend in person. I take the view that as a matter of ordinary language, that means attend himself and not by a representative. And then he goes on at paragraph 41. One can contrast the position under 39.3, and he summarises that provision before saying, for these purposes, a party attends a trial if he or she is represented by solicitors or counsel who appear, even if the party, him or herself, is not present at court, citing Rouse and Freeman. And then he says after the quote, I have no hesitation in agreeing that is a correct view of CPR 39.3, and if paragraph 5 of the Mitchell order had followed what His Honour Judge Mitchell in fact said on page 8 of the transcript, and then the quote is, in the event that he does not attend the resumed trial, it would no doubt have been appropriate to give it the same interpretation. But the addition of the words in person, which are in fact found in paragraph 5, seems to me to add something and make it clear that what is required for attendance is Mr. Abu Hamdan's personal attendance at trial.
Well, that illustrates, doesn't it? Milady's right about what Mr. Justice Nugee said, strictly speaking, in endorsing Rouse's overture, isn't it?
It is, but in my submission, persuasive dicta from the High Court setting out familiar general principles as to how civil litigation operates, and note that in person was required in order to make clear that personal attendance was required, because if the word defendant alone had been used, then the natural meaning would be in person or by his representatives. And that is, in my submission, how it is and how it should be. And I say respectfully that Gross J and Nuji J are obviously correct, both in terms of the general principles that apply and in the interpretation of CPR 39.3(1)(b). And if that is so, then in my submission it must follow that the same interpretation applies to CPR 27.9(2). You cannot have the same words used in the CPR in a materially identical context, trials, meaning two different things. That is not something that the Rules Committee would have intended. If I can briefly deal with the case my learned friend submitted yesterday.
Yes. Just a moment. Family Channel Limited.
That's right, and he's produced an addendum skeleton argument in which he suggests that this court treated attendance for the purpose of Rule 39.3 as personal attendance at trial. And that is entirely wrong. It's not how this court treated attendance at all. Family Channel and Riaz concern the non-attendance of the defendant at trial. And what occurred is set out in the quotes from the recorder's judgment, which begin at paragraph 8, page 5. And so we can begin at the indented quote at paragraph 8. The defendant has not attended today. Counsel is instructed to apply for an adjournment. He is instructed to apply to strike out the case, but without being provided with any bundles of evidence. He is not instructed in the trial. And then he goes on to be critical of the defendant. But the key point is, counsel was not instructed at the trial. We then go on to paragraph 9, and you'll see second sentence on the second line. He ruled that he would start the trial on the following day, after making arrangements for adjustments to be made to assist Ms. Fatima in giving evidence. She'd submitted evidence to suggest that she was unwell and therefore unable to attend trial. And then we get on to paragraph 10. Ms. Fatima did not attend the next day, 17th January 2019, nor did anyone on her behalf. And then paragraph 11, the recorder considered his earlier ruling in the light of this additional information, some further medical information. His assessment of Ms. Fatima's conduct overall was as follows. In my view, the defendant, by her conduct of the case, has disclosed that she has no real intention of attending trial. She has instructed solicitors to act on her behalf to strike out the claim, and failing that, to seek an adjournment on ill health grounds. Given the issues in this case, failure to provide the solicitors with instructions and funds to represent her at the trial must have been ongoing for some time. So, my lords, my lady, that is emphatically a case where there was a strikeout due to non-attendance of party personally.
Okay. What did this court say about it? I'll just remind myself. It's Lady Justice Carr.
Yeah, well, my lord, the issue on appeal was concerned with the jurisdiction to set aside an order striking out.
Was there any reference in Lady Justice Carr's judgment to
So
that
he didn't,
point?
sorry to interrupt, paragraph 13, the court didn't strike out the claim, he decided to proceed in her absence.
Yes,
Oh, I see, and he then struck out her
Yes.
defence. Okay.
yes, because that's the consequence for non-attendance of a defendant. I should have made that clear.
So what comment, if any, did Lady Justice Carr make about what the recorder had done and the interpretation of 39?
None, as far as I can see. The judgment then turns to the issue on the appeal, which was whether the judge at first instance was right to proceed in the absence and strike out, and then whether right not to set aside on the defendant's application.
You say no comment on this by Lady Justice Carr?
No, but what is clear is this is a case where there was no attendance, personal or by representatives. And then the report takes a different course. The issue was, in light of further evidence on the application to set aside, was it correct for the courts below to determine that they were bound by the earlier decision to proceed in a defendant's absence, in light of the fact there was no new medical evidence.
Okay.
That way.
All right.
It takes
So
a different
that
course.
deals with that. So where do we go next?
It's my third heading,
Purposes.
my Lord. Purposive interpretation supports the claimant's case. 4 subheadings. First, the claimant's interpretation is consistent with the proper effect of the notice regime under CPR 2791.
Just a moment. Consistent with the notice regime
Yes.
in 2791.
Secondly, significant practical problems will arise if a party is required to attend personally. Thirdly, by impeding a party's ability to attend trial through a legal representative, the approach of the courts below restricts access to justice. And fourthly, the approach of the courts below is contrary to the overriding objective. So if we can turn first to CPR 2791 and consider the notice regime set out by that provision. It's tab 6, page 32. See first the consequence of complying with subparas A to C. At the bottom, the court will take into account that party's statement of case and any other documents he has filed and served when it decides the claim. Now, in light of my earlier submissions on the interpretation of 2791 and the fact that it must be construed as anticipating service and filing of documents and the giving of notice by party personally or representatives, it must follow that the consequence of complying with subparas A to C applies where there is no attendance at all for the party. And it's obvious in my submission that the notice is intended to ensure, first, that the court and the other party know that no one will be attending for the party giving notice, personally or through representatives. Secondly, that the court and the other party know that the non-attending party wishes his claim or defence to be determined on the papers in his absence, personally and by any representatives. And thirdly, that such papers are before the court and served on the defendant in good time, 7 days before. My lords, my lady, there is no such regime where a party does not attend a fast-track or multi-track trial, and I've taken you...
Sorry, say that again?
There is no such regime where a party does not attend a fast or multi-track trial, and I've taken you to the relevant rule in 39.3. And in my submission, allowing a consideration on the papers rather than having the power to strike out for non-attendance is consistent with the objective of the small claims track of dealing with low-value claims informally at low cost. And I've set out in my skeleton argument at paragraph 49 references to various provisions of the CPR which spell out the well-known proposition that small claims are low value to be dealt with informally. And
Paragraph 49 of your skeleton.
Yes.
Thank you.
My next point is that the provisions of 2710 are of a piece with the notice regime. So that's overleaf on page 33 in the authorities bundle. Disposal without a hearing. The court may, if all parties agree, deal with the claim without a hearing. That's entirely consistent with what I say is the proper interpretation of 2791. If one party serves the notice, they won't be there and their case will be considered on the papers. If both parties agree, no one will be there and both their cases will be determined on the papers.
That requires both parties to give notice?
Just both parties to agree.
Okay.
Per the rule, it doesn't set out a procedural time frame in which to give notice to the court of agreement, for example.
Right, so it doesn't require both parties to give notice. It can be if they inform the court that they agree.
Correct.
Let's just read the note, just a second. So both parties, though, can give a notice
Yes,
if they want to.
they could, and that would presumably lead to the same outcome.
Well, it would, but it would be procedurally better because it would ensure that each party had made their documents available to the other 7 days before the hearing.
Indeed.
Whereas an agreement may or may not involve that having happened.
Yes.
Yeah.
We can turn to the practice direction.
Yes. Well, this is, I think, the point I was making earlier about the note immediately above.
I'm afraid it's not. I'm still keeping you in suspense on that, my lord. But it's
Right.
paragraph 5.4 of the practice direction. That's tab 6, page 44. And you'll see, where the judge decides the case without a hearing under Rule 27.10, or a party who was given notice under Rule 2791 does not attend a hearing, the judge will prepare a note of his reasons and the court will send a copy to each party.
So, I'm so sorry, I'm slightly behind. Where are you reading from? 5.4.
5.4, page
Thank you.
44. My lords, my lady, that provision anticipates the absence of any representative for the party who serves notice and does not attend the trial. The obvious purpose is if no one's there because it's a 2710 disposal of the claim, then obviously the judge needs to provide a written note of his decision and reasons, because no one will be there to know. It would be absurd if he provided an ex tempore judgment in those circumstances. But of
Well,
course...
As drafted, it would be mandatory, will prepare.
Yes.
Yes.
Yes, and that's dealt with in the decision of His Honour Judge Hassall in Manchester County Court in Mohammed and Churchill, which I've put in the authorities bundle. It's cited in the notes to the White Book, and he sets out what I say is the proper effect of the notice regime, and the references are at paragraph 34 of my skeleton argument.
Yeah.
In that case, the judge did not provide any adequate note of judgment, and His Honour Judge Hassall made the point that it's mandatory per the practice direction. Obviously, if one party is present and the other party is not, because he has served the notice, not personally present, no representative, then 5.4 functions to ensure that that party is aware of the outcome and aware of the reasons for it. If a party who served a 2791 notice and is not personally present in court, but who is represented, there would be no need for a written note of reasons, because the representative would be there to take a note of the ex tempore judgment.
Yes, I think probably the obligation to give reasons is a matter of law and also open justice.
Yes.
I'm not sure that derives from a practice direction. The practice direction just tells you how to do what you're lawfully required to do, namely to tell the parties why they've won and or lost.
Absolutely, my lord. Yes. Yes. Final point under this heading goes to the note to CPR 2791, tab 6, page 33 in the bundle. The notes at 2791, and you'll see there the reference I referred to earlier to Mohammed and Churchill, and just below that, the passage that we both rely on. Parties in person cannot give written notice of their non-attendance, but then attend the hearing by way of a representative appearing on their behalf.
And there's no authority given for that.
There isn't.
It's
I'm afraid.
a clear statement standing on its own.
It is.
But one which you both rely on.
My lord, exactly. What I say we can glean from that, whilst noting its limitations in terms of authority, is that if you look at the defendant's interpretation, a notice from a litigant in person would apply only to the litigant personally, and so there would be nothing to prevent the litigant, subsequent to the service of the notice, instructing a representative to attend on his behalf. And what the note makes clear is that a litigant in person cannot do that. And in my submission, the reason why the authors of the note saw fit to put that in the White Book is because the proper effect of the notice regime is if you give notice, you're saying no one's going to be there, either myself or any representative. And in my submission, looked at in that way, the 27.9 scheme is a coherent whole. The general principles as to attendance at trial apply per Rouse and Freeman and the interpretation of 39.31b, But this is the small claims track regime, where the strict rules of evidence don't apply. The court can adopt its own procedure. Low value claims, low cost, informal, and therefore a party can give notice, not attend, and the court can consider the case on the papers. That's plainly, in my submission, what the Rules Committee intended to create by way of a low-cost, informal regime for disposing of low-value claims. I'll move on then to my next subheading, which is the approach of the courts below creates practical problems, and I've set some of those out at paragraphs 35 to 36 of my skeleton argument, but the obvious problem is in respect of corporate parties. If my learned friend is right, every corporate party would require someone from the company to be in attendance in addition to the representative.
The thought did occur to me to ask whether, in fact, in this case, the defendant was attended the hearing before the Deputy District Judge.
Yes, well, my lord, I did make inquiries. I didn't represent the claimant at first instance. And my understanding is that the defendant relied on a witness statement from, I think, a Mr. Gill.
And attended by counsel.
Well, Mr. Gill then wasn't able to attend to give evidence, so his evidence was in due course.
Well, Mr. Gill won't be a director of Black Horse Ltd, I'm assuming.
No, indeed. There was then a Mr. Gilman.
Board.
I'm told there was another person, a Mr. Gilman, I might be getting the names wrong, who attended, not to give evidence, but just to attend. Of course, this was a CVP hearing, so Mr. Gilman was just on the video link. He may have had his camera on, he may have had his camera switched off, he may have had the mic on, mic off, speaker on, speaker off. If you think how these hearings actually operate, Mr. Gilman could have minimised his window. He would come up as a name attending the video hearing, but he could have done a day's work on something else while his little box was minimised in the corner of his screen. And it would be on that basis that the defendant was attending the trial and the claimant wasn't, before we even get on to whether he had the necessary authority.
Well, I had a more technical point perhaps in mind, which is that a body corporate can appear in legal proceedings by counsel and must do so, or solicitors where they have the right of audience and must do so unless the court has given permission that it can attend by an employee.
Yes.
Otherwise it's not present.
Yes. That, I think, is Rule 39(6).
Yeah. So I was just wondering whether the defendant in this case actually attended at the trial. You'd say it did because it was represented by counsel. Yeah,
of course. But on the defendant's own interpretation, it begs the question of what status Mr. Gilman had. But let us take the position that it would have to be someone with sufficient authority to constitute attendance by a body corporate. It couldn't be any employee. Then take a road traffic claim where the claimant company wishes to claim for damage to a works van and its witness is its employee. The employee attends to give evidence as to the circumstances of the accident. Has the company attended the trial? The company is represented by counsel. It could be said that the employee, the driver, does not have the status to constitute attendance by the company. Of course, another example would be the same facts, but where the employee has, since the accident, left the employment of the company. In that straightforward type of small claim, the company would have to send someone along to constitute attendance.
39(6) doesn't apply to small claims, though, does it?
It doesn't.
And the practice direction deals with companies at page 43 of the bundle, 3.2, subpara 4.
It does. And so the position there, per Lady Justice Arden in the case of Avenue and Sun Rule that I've included in the authorities bundle, is that the court's permission is not required
Yeah.
on the small claims track, but that's concerned with representation.
Sure. No, it's just that you were referring to 39.6, and my understanding is that 39.6 doesn't apply to small
Yes.
claims, and it's got its own little regime.
My lady, you're absolutely right. I was quoting the general rule, which is, of course,
Yeah.
disapplied. Take another example. One can spend a long time on these examples, but another road traffic example where an insurer is sued directly, relying on the European regulation. Does that mean a relevant person from, say, Aviva, Direct Line, or the like has to attend in order to constitute attendance by the sued insurer? What about claims for unpaid gas bills? It simply, my lords, my lady, wouldn't operate in any practical way if attendance was so required.
Are you going to say anything else about paragraph 3.2 of the practice direction?
Well, my lord, I'll take that point now.
When you get to it.
Yes.
You get to it. All right? You are.
I've already raised the issue of remote trials and the absurdity that would arise in requiring personal attendance at a remote trial, particularly by a body corporate. Other issues arise. Would in-house counsel constitute attendance by a company, but external counsel not? These are the sort of issues that would be thrown up, the precise answers of which, in a sense, doesn't matter for the purpose of this appeal. It demonstrates that it throws up difficult issues, which in the context of the proposition which has been made by Nuji J and Grace J in the High Court cases, there is no purpose served by requiring personal attendance. What about non-protected parties who are disabled, who are unable to attend court physically, maybe not able to attend remotely on a video link? Does that give rise to issues as to discrimination? See there the judgment of Lady Hale in unison. So, in my submission, when one considers what practically the defendant's interpretation means, it is telling against that interpretation. I'll move on then to the approach of the court below restricts access to a court. And I note the observations of Lady Justice Whipple in granting permission to appeal. And obviously, if the court is with me as to the natural meaning of the words in their context, it's not necessary for me to establish that the defendant's interpretation would give rise to a rule that was ultra vires. But in my submission, clearly 2792 falls to be interpreted in a way that is consistent with the constitutional right of access to a court, unless an impediment to that right has been clearly authorised by statute, which here would be the Civil Procedure Act 1997. And I say there is no such authorisation, and the Rules Committee can be presumed not to have intended to enact a rule that would be ultra vires. I rely here on R and Unison and Lord Chancellor, and if you go to tab 17, page 203, paragraph 66, the constitutional right of access to the courts is inherent in the rule of law. And then we can skip to paragraph 69. access to the courts is not therefore of value only to the particular individuals involved, that is most obviously true of cases which establish principles of general importance. Now, this might be a small claim, but by way of illustration, and by reference to footnote 5 of my skeleton argument, the Supreme Court has heard 2 PPI claims in the last 7 months, both of which started off as small claims track hearings, both of which involved non-attendance by the claimant personally. The claimant succeeded at first instance, the point wasn't taken in those cases, and important points of law ultimately were considered by the Supreme Court, and judgment is awaited in both those cases. So that illustrates.
So those cases are?
Those cases are Canada Square Operations and Potter, which concerns the proper interpretation of Section 32(1)(b) and Section 32(2) of the Limitation Act, deliberate concealment, and Royal Bank of Scotland and Smith, which concerns the proper interpretation of Sections 140A to C of the Consumer Credit Act.
And you say in both cases, it's right, a party did not attend, or a party was represented, did not attend personally, and the point wasn't taken?
Yes, I was counsel on both those cases, and I appeared alone.
In both cases?
Yes.
And they're both going to the Supreme Court?
They have both been heard. June for Potter, 12th of January this month, Smith. Yeah. If we turn on then to paragraph 78 of Unison, and you'll see second line, Lord Reid says, impediments to the right of access to the courts can constitute a serious hindrance even if they do not make access completely impossible. And that's the terrain we're in here, in my submission. And I would say to the court, see generally paragraph 78 to 82, which concern cases involving prisoners where measures were taken that made it difficult but not impossible for them to bring their claim. Next, the right of access to a court includes the claimant's right to have his case dealt with at a hearing.
Where are you reading from now?
This is a submission,
Okay.
my lord. The right of access to a court includes the claimant's right to have his case dealt with at a hearing at which his representative appears on his behalf without the claimant being personally present. Rouse and Falmouth Housing obviously support that proposition. But there's also the judgment of Lord Newburger in Bank of Scotland and Pereira. That's at tab 14, page 121 of the bundle. Paragraph 25. It is a fundamental principle of any civilised legal system enshrined in the common law and in Article 6 of the Convention for the Protection of Human Rights and Fundamental Freedoms that all parties in a case are entitled to the opportunity to have their case dealt with at a hearing at which they or their representatives are present and are heard.
I'm sorry, I've fallen behind you. Could you give me the reference in the bundle to where that is?
Page tab 14, page 121.
Thank you.
Paragraph 25.
Thank you very much.
And note, it's the last passage in the quote, have their case dealt with at a hearing at which they or their representatives are present.
Was that an issue in the case? Or
Again, it's obiter in the sense that, as with many of these cases, it concerned the jurisdiction to set aside.
yeah. So what he's saying is, if you meet the conditions in 39.3.5, then it would be bizarre if you weren't allowed to put your case forward.
That's the ultimate conclusion in the case. But in my submission, Lord Neuberger is right. The right of access to a court does include the right to appear by your representative in your personal absence, and that right is obviously impeded on the defendant's interpretation. And it's no good in my submission the defendant saying, oh, well, all you have to do is serve the notice. First, I accept it's not entirely clear from the wording of the CPR, but if the notice, as the note I took you to, excludes the possibility of attendance, see the idea if a litigant in person serves a notice he can't subsequently instruct a representative, then a party who cannot attend in person or is unable to attend in person, does not want to attend in person, is on the horns of a dilemma. They can serve the notice but then restrict themselves to a paper consideration of their case, or they can elect not to serve the notice, send along their representative, but then be at risk of strikeout. And that compares unfavourably to the position of a claimant who is able or willing to attend the hearing alongside their representative. But even if this court concludes that service of the notice does not exclude subsequent attendance at the hearing, the requirement to serve a notice itself constitutes an impediment because that requirement does not apply to the claimant who is willing or able to personally attend. They don't have to serve the notice. And the notice is a potential tripwire. See what happened in this case where a notice was served to protect the claimant's position but was defective as to its content. And the final point is the 7-day requirement. What if a party decides that he cannot or does not wish to attend less than 7 days before the hearing? He can't serve the notice. The notice will be of no effect because it's less than 7 days before. And so that party is stuck with his representative attending and therefore at risk of strikeout. And my lords, my lady, going back to unison, paragraph 78, that's page 206, tab 17. This is the last sentence at the bottom of 206. More recent authorities make clear that any hindrance or impediment by the executive requires clear authorisation by Parliament. And at paragraph 79, at the bottom, Lord Reid quotes Lord Bridge in the case of Raymond and Honey, a citizen's right to unimpeded access to the courts can only be taken away by express enactment. And in my submission, section 1.3 of the Civil Procedure Act 1997 contains no such authorisation. That section's at tab 1, page 3 of the authorities bundle. The power to make civil procedure rules is to be exercised with a view to securing that the civil justice system is accessible, fair and efficient. And the defendant's interpretation fails on all three bases. It's not accessible, it restricts access to those in the circumstances I've just described. It's not fair, not least because no purpose is served by requiring personal attendance of a party qua party. Because it's important to remember, we're not concerned here with non-attendance of witnesses. It's a coincidental fact if a party happens to have given a witness statement in support of his claim. He may simply be a party. This is concerned with attendance as a party. And it's not efficient. See the practical problems that I've identified. And then we can go to paragraph 80 of Unison. Sorry to skip around, that's back to tab 17, page 207. Paragraph 80, opening lines, even where a statutory power authorises an intrusion upon the right of access to the courts, it is interpreted as authorising only such a degree of intrusion as is reasonably necessary to fulfil the objective of the provision in question. And there's no such legitimate objective. There's no good reason why there should be an apparently unfettered discretion to strike out small claims track claims merely because the claimant is not personally present, even though his representative is. My learned friend's point in his skeleton argument is essentially there should be a jurisdiction to strike out small claims because they're small claims. And the final point on Unison is paragraph 88. The degree of intrusion, this is the last two lines, the degree of intrusion must not be greater than is justified by the objectives which the measure is intended to serve. So even if there was some benefit in personal attendance, strikeout is a disproportionate measure. See there the observations of Gross J and Rouse and Freeman at paragraph 16. So for all those reasons, I do say that the defendant's interpretation would constitute an impediment to the right of access to the court, and therefore would constitute an ultra vires rule if it was so interpreted, and that tells against that interpretation. That cannot have been the intention of the Rules Committee. All those points, moving on to my last subheading under this purposive heading, all those points support the proposition that the defendant's interpretation is not consistent with the overriding objective and is not consistent with the small claims track regime of low-value claims being dealt with informally and at low cost. And the simple point is requiring a party to attend unnecessarily is itself unjust and increases costs. And we can skip very quickly to the overriding objective. It's at tab 2, page 5.
Well, we're familiar with the overriding objective.
Yes. My Lord, you can look at each point, and in my submission, the defendant's interpretation fails. It's not putting the claimant on an equal footing. It's certainly not allowing him to participate fully in the proceedings. I've dealt with expense. It's not dealing with the claim proportionately, because it's either requiring the attendance of the claimant personally, or it's giving rise to arguments on strikeout every time the claimant elects not to attend personally. That is not dealing with cases expeditiously and fairly, and it's likely allotting a greater share of resources to those individual cases than is necessary. So I'll move on to my last point, which is that CPR 27.11 does not dictate a different interpretation. I had understood my learned friend to be saying that he had no quarrel with the interpretation given to 39.31b by the High Court, but that 27.92 was different because of the provisions of 27.11. And the headline point that I'd make is that the difference in drafting style between 27.9 and 27.11 causes neither difficulty of interpretation nor of practical application. An explanation for the difference in wording is simply not required. You interpret the words in 27.9.2. If you want wider context from surrounding rules, you look at 27.9 itself, and you have my submissions on that. What you cannot do is sacrifice the common sense interpretation of 27.9 on the altar of what my learned friend says is grammatical consistency with 27.11. If you conclude there is a grammatical quirk in the way that the draftsman expressed himself at 27.9 and then 27.11, so be it. If the interpretation of 27.9 that I've offered makes sense and is practical, the court shouldn't adopt a less practical and less common sense interpretation.
All right, so we're going to look at 27.11, yep?
Yes. That's page 33, tab 6. And you'll see a party, A, who was neither present nor represented at the hearing of the claim. So the draftsman here has split out personal attendance and representation. And 27.11 is setting out the circumstances in which a strikeout can be set aside. And if we go over leaf to subparagraph 3, the court may grant an application under paragraph 2 only if the applicant, A, has a good reason for not attending or being represented at the hearing. So again, attendance and representation has been split out in this rule. The word present is used in subpara 1 and the word attending is used in subpara 3, but in my submission they mean the same thing. I can't explain why.
Attendance, you're saying that attending in 27.11, 3A clearly means present.
Yes, and vice versa.
Well, why do you have to say vice versa?
Well, perhaps not. It doesn't matter. The point is, for whatever reason, the draftsman's used the word present in sub 1 and attending in sub 3, but it means the same thing.
Just a moment. Just a moment. Carry on.
The difference between 27.11 and 27.9 is not that the word attend means anything different in 27.11 as it does in 27.9. The difference is that here, reference to party refers to the party personally. And we know that because party has been split out from representative, or representative has been split out from party. But attend means the same. If Mr. Owen was here, sat at the back, he will have attended as a party, I will have attended as his representative. 27.11 is simply one of those rules or contexts where it was necessary, or the Rules Committee considered it appropriate, to split out party from representative. And I've already given an example of an order requiring attendance for cross-examination where claimant attend for cross-examination would obviously be a reference to the claimant personally. It's all contextual in my submission. My learned friend gives two examples at paragraph 9 of his skeleton argument of where party personally and representation is split out. So if we go to tab 3, page 7, the court's general powers of management, 3.12, except where these rules provide otherwise, the court may, C, require a party or a party's legal representative to attend the court. That is just obviously a context where it's necessary to split out party and party's representative because the Rules Committee wanted to gives the court the power to require a party's representative to attend but not the party, or a party to attend but not the representative. The Rules Committee could have drafted the rule as two separate rules: require a party to attend the court, and then a new subparagraph, require a party's representative to attend the court. It doesn't tell us anything about how 27(9) should be interpreted. And in my submission, the position is likewise for paragraph 3.2 of the practice directions of part 27 that my learned friend also refers to. That's tab 6, page 43. And here it says, a party may present his own case at a hearing, or a lawyer or lay representative may present it for him. Again, the purpose of that provision is to set out who may represent a claimant at a small claims tract hearing. And in order to achieve that, to set out who may do that, the wording necessarily has to split out party from representative. Again, it doesn't tell us anything about CPR 27.9. There is anyway, in my submission, a sensible explanation for why this drafting style was adopted. For whatever reason, the Rules Committee obviously considered it necessary to split out party and representation in CPR 27.11. That rule delineates the circumstances in which a party must apply to set aside, may apply to set aside, from those where he must appeal. And there are circumstances where a party can do both, but there are circumstances where a party can only appeal and cannot apply to set aside. And 27.11 is setting those circumstances out. If neither the claimant was present nor his representatives were present, then the jurisdiction to set aside arises. But if the representative was present and the claimant was not, there is no jurisdiction to set aside because there was a representative in attendance. And the route to challenge the decision is by way of appeal. That's the agreed effect of 27.11. Now, because there is a greater scope for lay representatives on the small claims track, and perhaps not as a matter of the rules, but just as a matter of practice, a greater scope for litigants in person, it may well have been that the Rules Committee considered it important to make clear the circumstances in which a claimant can apply to set aside from those where the claimant must appeal. That's not necessary for CPR 27.9.2 because it is a judge that decides whether to strike out the claim for non-attendance at the hearing. So the Rules Committee can be presumed to have thought that the judges would know that where a representative attends for a claimant but the claimant is absent, there is no jurisdiction to strike out.
Is there any provision under, do you say, where a claim is struck out under section 27.9, in which the judgment cannot be set aside, on your interpretation?
No, because the claim can only be struck out where the claimant is personally absent and there is no representative present.
If the respondent's and the judge's interpretation is correct, and a claim is struck out where a representative attends but not the party, and no notice was given, then the claim, then there is no pad to set aside.
There is not. No. The route would be appeal. So there is then an incongruence between circumstances in which a claim could be struck out for non-attendance and the circumstances in which a striking out for non-attendance can be set aside.
And also, where the part on the respondent's interpretation, where the respondent wasn't, where a party wasn't present, but was represented, and a notice was given, and the claim struck out, again, there would be no power to set aside.
Correct. So, that is not a coherent scheme in my submission. And if I can just elaborate on why the Rules Committee might have drafted 2711 as it did.
My lords, I'm a little conscious of the time.
Yes, well, I'm anxious to, obviously, to beat this case by 1 o'clock. I think Mr. Butters is coming towards the end of his submissions. And obviously, we've covered a lot of ground which we won't have to repeat. But Mr. Neville, you'll get every chance, don't worry. Yes?
Yes, I certainly am coming to the end of my submissions. The reason why 2711 may have been drafted as it was is if you have a lay representative who can represent a claimant without the claimant being present if the court gives permission, those are the provisions at 3.2 of the practice direction that you referred to earlier, my lord. So there is a lay representative's right of audience order, 1999,
Yes.
that provides that the lay representative may not exercise any right of audience, A, where his client does not attend the hearing, but then 3, however, the court exercising its general discretion to hear anybody may hear a lay representative even in circumstances excluded by the order. So imagine a situation where a lay representative attends a trial, the claimant is absent, the claim is then struck out, perhaps for some other reason. Important to tell the lay representative when he can apply to set aside and when he can appeal. Because the decision whether to go down the set-aside route or the appeal route is not one taken by the judge, it's taken by the party, possibly advised by his lay representative. So they've spelt it out when you have to apply to set aside, when you have to appeal and when you can set aside. As I said, no reason to do that 27.9 because it's the judge making the decision. That's the explanation in my submission. And the better question is, if CPR 2792 has the meaning that my learned friend contends, why didn't the Rules Committee split out personal attendance and representative attendance in the rule? Why does CPR 27.9 not say something like, even where his legal representative appears on his behalf? 27.11 shows that when the Rules Committee wants to split out personal attendance and representative attendance, it does so. And the reason that the Rules Committee did not do so in 27.92, but instead followed the wording of 39.3, is because it wasn't making a distinction between personal attendance and representative attendance. Attend, for the purpose of that rule, means attendance by the claimant personally or through his representatives. Unless I can assist you further, those are my submissions.
Thank you very much, Mr. Butters. Now, Mr. Neville.
My lords, lady, I'm much obliged. I heard your lordship's observation that obviously that the facts of this case are not relevant.
Well, that was only my preliminary observation.
No.
We haven't had any reference to the
But,
facts
uh,
so
the
far. If you
background-
want to say anything,
The
then
background, very briefly, is instructive because, as you've heard, the trial of the matter took place by video in the small claims track, and the claimant did not join the hearing. No reason was given for his non-attendance, and no application was made to adjourn. And that the Deputy District Judge at the small claims hearing had pre-read the evidence, concluded that in the absence of oral evidence from the claimant, his claim was bound to fail. And after hearing submissions from the claimant's representative, the judge decided that it was in accordance with the overriding objective that the claim should be dismissed.
Struck out.
Indeed, dismissed by
If he'd heard
in
the
exercise
case.
of his discretion under
Yes.
Rule 29.
Exactly. If he'd heard the case, decided his provisional view was right, it is without merit and hopeless,
Yes.
then he might have dismissed it on the merits following a trial.
It appears that that would have been, from the very trenchant observations from the pre-reading, that was the Deputy District Judge's view, and he was not shifted from that, having heard representations from the claimant.
the point my lord is making is that the course then would be to dismiss rather than strike out.
The judge could have allowed the hearing to proceed, and at the end of the trial, having heard representations and been taken through the evidence, then reached the same decision.
But he didn't.
He didn't.
And why was his course better? Bearing in mind everybody was there for the trial.
It is better because of the circumstances that arise in relation to small claims cases. At the coalface, there are a very large number of cases that are listed for hearing before deputy district judges and district judges in small claims on the same day. They have an immense workload, and there is a tremendous burden put on them to apply the overriding objective and to arrive at a just decision as promptly as they can and as efficiently and effectively as they can. Now, the claimant doesn't contend in this appeal that if the judge had that power, that the exercise on these facts was contrary to the overriding objective.
Has that point, has he got permission for that point?
It wasn't. It was abandoned at the first appeal.
Okay, so it's not before us.
No. Instead, they're contending that the judge had no such discretion. In effect, judges have to allow the trial to run its course, even if the inevitable outcome is dismissal of the claim. We say simply that the judge has that discretion, although, of course, like all discretions, it can only be exercised if it is if it's exercised in accordance with the overriding objective. My Lord's Lady, if I can move on firstly to what is the clear grammatical meaning of attend in Rule 27. Now, plainly, of course, it is one applies the principles of statutory interpretation when interpreting the civil procedure rules. They're given effect by statutory instrument. And when doing that, when conducting that principle of statutory interpretation, it is for the court to read the rule as a whole.
Rule or rules?
Well, the rule in this case, I would say, because Rule 27 deals with a distinct jurisdiction with its own regime, as as I've indicated, of course, the lion's share of evidential and procedural provisions in the CPR are disapplied. And we have far greater leeway which is allowed to a judge hearing a small claim. By way of example, Rule 27.8.1 provides that the court may adopt any method of proceeding at a hearing that it considers to be fair. And we say that the ability to exercise that discretion and not sit back and allow and be required to allow a trial to run its course is entirely consistent with that setting.
I'm assuming that, was there anybody there actually to give evidence at all in this potential trial?
No.
So the difference
there were
between
two.
striking it out and allowing it to run its course in this kind of case, where they probably list about 20 a day in front of each judge, it is not great, except that if you strike it out, you might end up here.
In this particular case, that would probably be so. The judge could have dispensed with representations from me. There would have, once the trial process starts, of course, Mr. Durkin, who is appearing for Mr. Owen, would have he would have needed to have to be entitled to make fuller submissions, notwithstanding the conclusion, which is not disputed as being an appropriate conclusion by the other side. So he would have, in effect, had to sit back and allow fuller submissions on the evidence and the underlying law, even though the outcome was inevitable.
Well, how do you know the outcome's inevitable until you've listened?
Well, we know it was plainly, in my submission, it would not be appropriate, in accordance with the overriding objective, to exercise this power unless a court reached the conclusion that the judge did in this case. That is, that in effect, a claimant's case is not going, cannot succeed without in the absence of a claimant attending to support the witness statement and be cross-examined. One can think of many examples, lady, of if perhaps with a simple car crash or an assault, if a person, if a judge, having read the papers, is fairly of a view, and it is an appropriate view to be in accordance with the overriding objective, that the case that insufficient weight can be given to the witness statement. With that, if a party does not attend, and gives no reason for the non-attendance, and that having formed that view, like all discretions, my lady, it can only be exercised where appropriate. If my learned friends' arguments hold sway, then it would mean that even when it is entirely appropriate to foreshorten the hearing, the court is powerless to do so.
And do you accept that if the claim was struck out, if your interpretation is right, there would be no power to set it aside in these circumstances? Set the striking out aside.
The only course would be appeal.
Why? What's the logic behind that?
Well, the rationale behind Rule 2711 is that if the claimant's representative was present at the hearing, the claimant's representative could then make submissions as to whether the set-aside was appropriate. Whether the strikeout was appropriate. So, in effect, with a representative there for the court to hear whether this is an appropriate step to take, then in effect the arguments have been run, and the appropriate procedure under Rule 2711, one would understand, is for then for any challenge to that to go by way of appeal. If there is no claimant's representative at the hearing, then those arguments have not been heard by the court, and so it is unsurprising that that is the gateway to allow an application to set aside for those arguments to be aired.
Yes.
My Lord, looking at the question of interpretation of Rule 27, and it should, in my submission, be interpreted as a whole, because it is within its purview. It actually contains. It is a self-contained structure for the hearing of small claims. In short, Rule 2792 says if a claimant does not attend the hearing and give notice referred to in paragraph 1, the court may strike out the claim. And then the mechanisms for applying to set aside to strike out, to set aside a strikeout under Rule 2711.3 says that for the court to grant that application, an applicant has to have had a good reason for not attending or being represented or giving the written notice.
Yeah.
Now, the very fact that it is clear beyond dispute that the Rules Committee, when drafting that, did not consider that attending meant being represented. Not attending or being represented would be a nonsense if the Rules Committee meant that attending included being represented. It would be a linguistic nonsense, because the two terms, if the learned friend submissions are to be believed, the two terms would be tautologous.
So your point is that 2711.3a, the word attending must mean in person, and therefore the whole of 27, attending must mean attend must mean in person.
There are plenty of instances where in the CPR where attending is used to mean being present. That is, if a party attends, the reference is to that party being present. And plainly, of course, when we're talking about a distinction between a party simply filing a witness statement and relying on that, or attending a trial to give oral evidence and be cross-examined, one can understand the significance of that. The test, as I've indicated in my skeleton argument, has been adopted verbatim by this court in Kennedy and Abu Bakr, and where the court considered whether the appellant had good reason for not attending or being represented. Now, plainly, that court did not consider this to be a linguistic nonsense, as the appellant in this case would have this court hold.
Are you taking us to that case?
Yes, I'm happy to do so. What is
Take whatever course you want. You just refer
absolutely,
to it.
absolutely. I'm pleased your hands. Yes, it is at A15,
15.
and it's page 137. I don't know if you have a tabbed version or if it's easier for me just to refer to the page numbers.
Well, we've got tab 15. What page number?
The case starts at page 137.
Yes.
And the relevant references have the benefit of a line down the margin at page 138. My lord, you can see the context. It is a consideration of Rule 2711, and the issue in this case, you can see, is summarised at the top of page 139. The issue is whether or not the appellant had good reason for not attending or being represented at the hearing. The fact that that was the issue that was being considered by the court is repeated on a number of occasions. You can see the I've got a highlight on page 141, 3/4 of the way down, at 147, at the again 3/4 of the way down, twice on 149 around the middle of the page.
Well, these don't consider, these references don't show this court, or Judge Etherton, considering this specific point that we're concerned with, do they?
They do not.
And what we're clear about is that 2711 uses attend and to mean personally present. 2711(3),
yes.
it says that, and 27(1)(a) talks about present.
Indeed. The test has been, in effect, was applied and adopted, and there was no response by the Court of Appeal in that case to say, well, this of course is a nonsense because you attend if you are represented. My learned friend would say this is a nonsense. Such a phrase. If it's not a nonsense, if it actually that attend does actually mean a party attending in person in order to give heft, in effect, to their witness statement and to give it some probative force, then it would plainly apply.
Your submission is they've got to be there, even if they haven't done a witness statement, because they haven't got any relevant evidence to give.
Well, no one has to be at a hearing. All we say is that the court, that if, in accordance with the overriding objective, if the non-attendance, it gives the court the option to, in effect, prematurely end the hearing at its inception.
Why does the court need that option? If the party isn't giving evidence, say the party's evidence is from somebody else, that witness attends, all the documents are in order, the party doesn't attend but is represented by a lawyer, Nonetheless, the court has the power to strike out. So why is that inconsistent?
There are-
What principle is
yes.
that consistent with?
There is a danger in my submission of this being viewed very much through the spectacles of an overview of civil litigation in this country, including large-scale hearings there are a number of very significant differences between the small claims track, of course, and other litigation. There is usually no adverse cost consequences of losing for a claimant, and so there is little.
I'm so sorry to interrupt, Ms. Neville. I just want to understand why you've taken us to Kenny. What do we get from Kenny?
Simply the fact that my own friend would say that not attending or being represented is a nonsense.
But it wasn't an issue in the case. Nobody pitched up at the hearing in front of the district judge, and I just don't.
It wasn't an issue. But what I'm saying, lady, is that that in Rule 27, attending plainly is intended to mean being present. Because Rule 27.11.3 draws a distinction between attending and being represented.
But you don't need this case. You're just making a submission about the language of the rules, aren't you?
I am. The only function of referring to it, lady, is that it has been, as a test, it has been adopted. And at no stage was it suggested.
The distinction between being present and represented arise in that case. I don't think it did at all.
No. It is
the three passages you've just referred to. Lord Justice Etherton just quotes what's in the rule.
Indeed.
Without comment, because it doesn't arise.
Absolutely.
If he made any comment,
yes,
to support your submission, it would have been obiter in any event, wouldn't it? Anyway.
Well, I'm not sure it even counts as obiter, but the fact is that it was at no stage was it suggested that is a linguistic nonsense. But quite plainly, in Rule 27, attend means being present, not being represented.
Well,
Otherwise, I could not have that test.
27.11, attend and being present are used interchangeably.
Yes.
At the moment,
Yes.
For my part, I think that's.
And we would
established.
say that given that Rule 27.11 is a direct sequelae from the and follows on very directly from Rule 27.9, that same meaning for attend must apply to Rule 27.9. Otherwise, it would be a nonsense. I go on to in my skeleton to list some of the examples where where the notes to the White Book do anticipate that attend is distinct from being represented, and I list them.
Yes.
In my skeleton argument, I'm not sure that they would take the matter further. It's the note Rule 27.11.1.
Which paragraph in your skeleton are you particularly referring to
now? Yes, it's paragraph 14.
Okay, thank you.
as you can see, the note 27.11.1 states that the right to apply is not available to a party who attended the hearing, was represented at the hearing, who gave a notice, or who agreed the case be dealt with without a hearing. Simply examples of the use of attend as being distinct from being represented is adopted by the notes in the White Paper. And the same relates to Rule 27. Sorry, Note 27.11.3 in the note on Kenny and Abbey. The note at Rule 27.11.3 does go on to give an example of a good reason as being, e.g., a medical certificate, and that anticipates that what one is talking about is non-attendance by the litigant, him or herself, because of course a medical certificate would not be grounds for say in extreme situations, for being unable to have someone appear to represent you at the hearing. It would impede your attendance in person. I'll come on to that briefly at the end in relation to Rule 39.3. If I can move on to or perhaps come back, I should say, to complete my submissions on the fact that if a discretion can only be exercised in accordance with the overriding objective, then it cannot. Then allowing the court that discretion cannot be in breach of it. Now, there are, as I've indicated, very good policy reasons for allowing a judge at a small claims trial or wide discretion to foreshorten a hearing. One can readily anticipate that if the outcome, if a claim, perhaps in an assault or a road traffic accident, or in a situation such as this case, where the on the face of it, the judge was determined that there was going to be insufficient weight given to a mere hearsay statement, to a mere written witness statement, for the claim to succeed, to be able to foreshorten it. Now, that on this occasion, the defendants, it was a witness from the bank who merely produced documents, but the defendants, I'm sorry, I should say that in many cases, of course, the defendant's witness would be in attendance, and if the judge did not foreshorten the matter, he would the judge at the small claim would then be required to sit and listen to extensive cross-examination, even though the judge has decided, in effect, that the claimant has not come up to proof on the claimant's case.
Well, you'd think that Rule 27.8
Yes.
would give the court plenty, and the note to that by the editors would give the court plenty of power to do
Yes.
that.
If in that case it is
Simply
really
saying, if defence counsel was inclined to call their witness, say, why are you doing that?
There are various mechanisms that could be used by the court to arrive at the same end, it is true. There is a problem, of course, that the claimant's representative might insist on having a right to cross-examine.
Yes, which might be denied.
Yeah, it might be. In such a situation, one is in effect talking about, in my submission, it's a distinction without a difference. In that,
Well, not really. The distinction is between striking a claim. It's a significant distinction.
Yes.
That's being old-fashioned, but striking a claim out is one thing and trying it is another. How you conduct the trial depends on the issues and the scope and proportionality of the question. And if there's nobody there to prove the claimant's case, it might be a very short trial indeed.
There is a certain amount of baggage that comes with the expression strikeout, because of course one anticipates that is frequently used in the context of a decision which is arisen from a technical infraction of a rule without any consideration of the merits. The distinction here is, of course, that this is simply a mechanism for a judge at the trial to foreshorten the trial. And that is a huge difference because, of course, it would only be at trial appropriate for a judge to take the stance that he did and, in effect, foreshorten the trial, having seen the evidence. In this case, of course, the judge had pre-read the evidence and formed the firm. Now, one can anticipate that strikeout is also used in the context of a remedy imposed without reference to the merits for a technical infraction. So if one is late in doing something or something is not filed, that is not this case. We're talking about the parties assembled for the hearing, and this is the only mechanism which is articulated in the under Rule 27 in the small claims track for a judge to in effect foreshorten it where the outcome is clear. And
didn't intend to do this, Mr. Neville, but you said that the parties were there for the hearing. I thought your argument was that one of the parties wasn't there.
I'm sorry, that was a slip.
Yeah.
I said that, lady. As I've indicated in the small claims track B, there are many and various, there's obviously a very pressing reason of public policy to allow cases to be disposed of if the outcome is inevitable. Very strong ones. There are, but also because of the disapplication of the bulk of the CPR in relation to hearings and procedure, there is no obligation to file witness statements unless expressly ordered by the courts. And, of course, applications for summary judgment in this context are largely impracticable. The intention of a small claim is that it comes on very rapidly. In effect, the small claim hearing can take over the role of being a summary judgment.
Does it follow from your submission that where a party has not given notice and doesn't attend, but a legal representative attends, he may not address the court without the court's permission?
My understanding is that there are provisions in relation to a lay representative.
Yes, that's
I think
right.
that's the only instance when permission is required for a lay representative.
Well, if we look at page 43, this is why I'm asking you really, in the practice direction, paragraph 3.2, a party may present his own case at a hearing, or a lawyer or lay representative may present it for him.
I'm sorry, my lord.
Page 43, behind tab 6.
Page 43,
Sorry,
I'm much obliged.
Mr. Neville.
Yes.
So, 3.21, a party may present his own case at a hearing, or a lawyer or lay representative may present it for him. But, 2, the order, that order there, provides that a lay representative may not exercise the right of audience where his client does not attend the hearing. So in those circumstances,
Unless the court exercises its general discretion further down.
yeah,
Under perhaps understandably, if the claimant, for example, doesn't attend, and but a lay representative arrives at the hearing, the court has a discretion whether to hear that lay that soi-disant
isn't it implicit at least in the way that paragraph of the practice direction is drafted, that a legal representative does have the right to exercise the right of audience in the absence of his client?
Oh yes, yes, absolutely.
But how is that consistent with your interpretation of 27.9?
Lord, it is simply a discretion.
What is discretion?
Rule 27.9, that where there is no notice given of the intention of the claimant not to attend, the court can
so the right of audience. The right of audience is qualified, you say?
No, there is no suggestion that the court would, under Rule 27.9, refuse to hear a representative. In fact, it is built into, it's hardwired into the structure which has been created by Rule 27, that the presence of the representative, who then could give, who could then make representations as to whether the...
But the right of audience is the right to present the case under 3.2.
Yes.
You're saying the lawyer would not have the right to present the case, a right to present the case, because that right is subject to the discretion to strike out if the lay party hasn't attended. Is that right?
The strikeout at trial would in effect be equivalent to a summary judgment application. It would be the small claims equivalent of the small, because the party, because I'm sorry, I said the parties are there, because because one has a hearing, and the evidence has been is before the court, and the parties are ready to make representations. And if a party is in attendance, then that person can be cross-examined. This is in effect.
Forgive me. A strikeout is not the same as summary judgment, is it?
Well, it is because the strikeout occurs at trial, can only be exercised in accordance with the overriding objective, and is only immune to an application to set aside if there was no representative present to make representations as to whether the discretion should be exercised in this case.
I mean, I may be wrong.
It doesn't impact on the. It doesn't.
Forgive me, I may be wrong. My colleagues may strike down what I'm saying before it's out of my mouth. Isn't a strikeout without any consideration of the merits of the claim, whereas a summary judgment is on the basis of a consideration of the merits, albeit a summary one?
Absolutely not.
You disagree?
Firstly, it is a discretion, and if it takes place at trial, then it can only be exercised in accordance with the overriding objective. And the overriding objective to foreshorten a hearing will only be satisfied if, in effect, justice has been done, i.e., there is that the case has been legitimately foreshortened because of such grave inadequacies on the strength of the claimant's case. So, in effect, if the case is hopeless on its face, and there will be plenty like that in a small claims court, because as I've indicated, there are no consequences generally of losing. It is a cost-free environment, and there are going to be plenty of cases that have no substance. There has been no mechanism for overview prior to arriving at the hearing, one sits down to have the trial, and what we say is that if it is in accordance with the overriding objective, there is a mechanism here for a judge to determine those that are hopeless. Once if a party, if the papers are before the court and the judge looks at it, there is a. I understand that an alternative mechanism might be to for the judge to, in effect, prevent any representative appearing on behalf of the absent party from cross-examining a witness or any of the witnesses. He can intervene with submissions on the merits.
Sure, in terms of dealing with the matter quickly, surely the judge would say in these circumstances, well, I've read the papers, and he would turn to client. Can you just give me your submissions in outline? What are your submissions here? Deal with them quickly, and then say thank you. I need to hear from the other side and give judgment. I mean, isn't that the way small claims work?
There would be there are many instances, particularly because sometimes with a low calibre of representative, where these hearings can, where representatives can insist on continuing to talk, and they can also insist on lengthy and somewhat entirely fruitless cross-examination. And there is
the judge has the power to stop that, and is encouraged to abbreviate hearings in those circumstances.
Yes.
And will be supported by the senior judiciary in doing so.
Yes. But all the more so that there is, as I've indicated, it is only in situations such as that where the overriding objective would permit the discretion to exercise the Rule 27 9 procedure.
If it's a discretion to strike out a case because it's hopeless, actually it doesn't really matter whether the claimant as a party is there or not, does it? I mean, that's not the rule doesn't give you the discretion you say you want, which is to strike out all hopeless cases.
Yes.
Because you're going to have a section A, you don't have a summary judgment stage. What
Rule 27.9 targets is a situation where a claimant's case would be determined, in effect, is reliant on the weight that is to be given.
27.9 provides a procedure whereby a claimant can have his case determined on the papers. That's what 27.9 is about. That's the contribution
it is.
Which it makes to the process.
It is a mechanism whereby if a party does not attend to support the case, then the court can determine, in effect, that the case is hopeless and bring the hearing to an early conclusion.
No,
unless
I'm putting to a different point. I'm putting to it's an integral part of the scheme of small claims that a party can elect to have the case determined, his case, or her case determined entirely on the documents. But to do that, they have to go through the hoops in 27.9.
That's Rule 27.10. There's an agreement between
27.10 is different. That's agreement.
Agreement.
We're talking about each individual party has the right to say that I want as far as my case is concerned, I rest it on the documents. And in which case the court then proceeds, as far as that party's case is concerned, on the documents. But in order to have that happen, the party concerned has to go through the hoops in 27.9. Anyway,
it is certainly true, my Lord, that the focus is on the evidence rather than argument.
Okay.
Because in my submission we are in a I'm sorry. If Rule 27.9.3 indicates that,
is about defense.
Yes, it's page 32 in the bundle, A632. if the defendant does not attend the hearing or give notice referred to in paragraph 1, and the claimant either, 1, does attend the hearing, or 2, gives the notice referred to in paragraph 1, the court may decide the claim on the basis of the evidence of the claimant alone. Now, on the face of it, the requirement for 7 days' notice appears to be a version, albeit a boundary-rise version, of the hearsay notice, because of course the hearsay provisions don't apply in the small claims court. So we have a situation here where in the absence of 7 days' notice of an intention for the defendant not to attend the hearing, that is, not be present, the court may decide the claim on the basis of evidence of the claimant alone. So it's a robust version of the hearsay notice for the litigants themselves. Now, there is no reference there to, of course, to representations, which again highlights the fact that the focus is on attendance by the party, in effect.
Does attend in 2793B 1 mean in person?
Present, yes.
If the claimant is present,
yes,
in person,
or gives the notice,
yes. So
then
supposing the claimant doesn't attend but is represented by
well, there is scant logic.
Can the court decide the claim on the basis of the evidence of the claimant alone?
Well, there is scant logic for attendance by a representative preventing a court from disregarding a party's evidence. What we have here, in a rough and ready way, is a mechanism whereby, in effect, the court has a discretion to not pay, to not in effect give any weight to a party's witness statement if that party has not attended. Exactly the scenario that I was outlining earlier, where we have a position where if a case depends entirely on the credibility of a witness, perhaps a fight or an road accident, the court, if the witness statement is simply insufficient to establish a party's case, the court can, in the absence, if that person does not attend the evidence and hasn't filed what is a form of hearsay notice, that is, notice that he's not going to attend, then the court will decide the claim on the basis of the evidence of the party that is in attendance and disregard, in effect, solely on the basis of. So it is a form of hearsay notice provision, but with added teeth. But of course, those teeth only apply for non-attendance by the actual party himself, because of course one can understand that in a small claim in particular, one is not necessarily going to have control over what witnesses appear for you.
Now, looking at your points about the claimant's arguments,
yes,
we've read what you've said. What else do you say about
very,
that?
very briefly, there are a series of factual scenarios that are outlined by the claimant, in which it would be inappropriate, they say.
You say that those concerns are covered by discretion.
And one could say that with any procedural rule. One could turn around and say, well, none of the provisions, case management, that appear in the CPR are in effect valid or effective, because we can come up with innumerable situations where they shouldn't be applied. None of these discretions that a court has, none of the, if I can come up with 100 examples of when it would be not in accordance with the overriding objective to exercise that discretion, the court can't have that discretion. The court can't have that power. So quite plainly, if one is talking about a situation such as a company or a disabled applicant, it plainly would not be exercised in accordance with the overriding objective. Now, given that, my own friend also has very boldly suggested that this is an impediment to the right of access to the courts. Now, as I've indicated, given that it is at trial, it will be merit-based decision, because the evidence will all be before, all the documents and all the evidence would have had to have been read by the court before it can exercise that discretion. And it has to be exercised in accordance with the overriding objective. It cannot be an improper impediment.
Okay. Now, looking on in your document,
yes.
We now come to the 39.3 cases.
Indeed.
And your point essentially is, in paragraph 34, the rules are radically different.
It is, but also the context is different. And that is perhaps apparent from the fact that the learned judge in Rouse appeared, if this doesn't seem disrespectful, appeared relaxed at the prospect of a different interpretation applying to Rule 27. I did not feel the need to determine that issue one way or the other, on the basis that the relevant passage, it's paragraph 22 in Rouse, it's at page 86
But
of
it
the...
wouldn't have been appropriate for Mr. Justice Gross to have decided what that rule meant, because he's heard no argument. That's not what the case was about.
Indeed, but the argument was put that Rule 39 should be interpreted to be in the same way as Rule 27, and that and in effect it was clear from Rule 27 that attend meant to be present. And therefore, and the judge, rather than determining that, there's no criticism whatsoever, and in fact, it is. It simply supports what I'm saying. That he says it doesn't affect his. That's Rule 27. This is Rule 39. Therefore, I feel no need to determine what the correct interpretation is in relation to Rule 27. I'm going to make my ruling in relation to Rule 39, and that is not affected by what the position.
What he
might
said
be
was, I'm not expressing any concluded view about 27 and 11.
For present
Even if Mr. Redford is right as to it, it does, and that leads to inconsistency, I'm not persuaded my conclusion on 39.
Indeed. Indeed.
That's all it says. Right.
Now,
but what do you say about the principle in paragraph 16 applying under to small claims?
Yes.
Why doesn't the principle? I mean, it does apply, but why shouldn't it apply?
Yes.
Why shouldn't we adopt the same view?
I would say that, firstly, of course, I don't need to address the issue in relation to Rule 39 because
Yes,
entirely different.
I'm not putting that point to you.
I understand.
The point I'm putting to is, doesn't the point that Mr. Justice Gross makes in paragraph 16 apply, arguably even more so, in small claims? There are a great many situations where the person attendance of party is irrelevant, or at most unlikely.
Yes, indeed. The judge plainly is influenced by the fact that there are a great many situations where the personal attendance of the party is irrelevant. To which, as I've indicated, there are a great many situations when any rule and any discretion the court has should not be exercised. That does not mean that the court does not have the discretion where personal attendance is highly relevant and in fact vital. Secondly, in Rouse, the observations were made in the context of a decision which is plainly right on the facts, because, as can be remarkably, the trial judge in Rouse, and this appears, it's page 83 in the bundle, paragraph 2, in the bottom quarter, there is the circumstances in which the judge struck out the claim. The circumstances are remarkable because there appears to have been no assessment by the trial judge as to whether the claimant could establish his case without giving live evidence. And plainly, this was an inappropriate use of the power under Rule 39(3).
Now, Mr. Neville, I'm not putting you under any pressure at all. If we have to come back after the adjournment, we will,
Yes.
at some point. Approximately how much longer? I can see where we are on your written document.
Yes.
We're nearing the end. How much longer are you going to do?
I think another 10 minutes if the court will hear me. I'm aware that might encroach in your...
Should we sit to finish? Yes. It would, if you don't mind, Mr. Neville, and if it's not inconvenient to Mr. Butters, it would very much suit members of this court if we could sit to finish.
Yes, much right.
Thank you.
The next point is that the judge fully accepted that it would be appropriate, of course, understandably, to give judgment against an absent party who was a key witness. That would the observations that the judge make are very particular to large-scale litigation. He states at paragraph 21,
it's really paragraph 16. I'm sorry to drag you back there.
yes,
But what part of paragraph 16 do you say does not apply to small claims? I recognise it doesn't. It's not. He's not talking about small claims.
yes.
But
Paragraph 16 is an example of plainly when this discretion should not be exercised. If a party is not, if their evidence is not crucial, and the same apply, then plainly it will be to the success of their claim. Then plainly the discretion should not be exercised. And as I've indicated, the same goes for Rule 27(9)(3). It's page 32 in the bundle. In that plainly it would be inappropriate to disregard the defendant's evidence in its entirety, simply because the defendant did not attend and had not filed the hearsay notice, the Rule 27 notice, unless the attendance was pivotal and essential for that party to succeed in the case. It would be other Rule 27(9)(3) would be an outrage if that were not the case.
right.
Rule 27(9)(3) gives the court, in a small claim, a robust mechanism for in effect, summarily foreshortening a case, exactly in the same way as the other aspects of Rule 27(9).
Okay. Now, is it Falmouth? Moving on to the Falmouth case next.
But if I could just, in relation to what influenced the observations by Mr. Justice Gross,
Okay.
he then was, it's simply, it's page 86 in the bundle, paragraph 21. Considerations of practicality don't necessitate second thoughts as to the true construction of part 39(3). In effect, in a multi-track trial, a court can be prepared to sit back and allow justice to take its course, secure in the knowledge that a losing party is going to be paying the costs, and be picking up the tab. There are no such constraints in a small claim. There's no costs, sanctions generally imposed on a party for a claimant who runs a hopeless case. And so considerations of practicality for allowing a trial to run its course, even with robust measures by the judge, unarticulated by Rule 27, are very much at the foreground of an interpretation of Rule 27, whereas they would not be. It is understandable that if both parties are in the firing line for costs, that a court can sit back and allow them to, in effect, pay the consequences if they waste the court's time and end up losing. This is a costs-free environment in the small claims where people can come and air claims that quite often have no substance. And the only articulated mechanism for a judge, for a court, for shortening it is basically on a decision on the merits is set out in Rule 27. In relation to Falmouth House, I've set out in my skeleton argument, Judge, the context evidently again was entirely different, and it was a remarkable case in which the learned judge held that there was no difference to the litigation whether the defendant was physically present or not. Perhaps the suggestion that there should be some sanction meted out in a situation such as that for non-attendance is understandable. It does not mean, of course, that should be the case where the significance of the oral evidence of that party is pivotal. My Lord, there is a difficulty with the interpretation in Rouse, and it is one which perhaps would have created pause for thought if the court's attention had been drawn to it. And this is that at page 67 in the authorities bundle, one can see that an application from a party who failed to attend the trial can only, to set aside a strikeout, can only apply if the applicant had, you can see B, a good reason for not attending the trial. Now, if attending means present or represented, then they would have to demonstrate that they had a good reason for not coming in person or being represented. There are the notes to Rule 39, 3.5 in the White Book are full of considerations along the lines that I have been that I mentioned. The fact is that a medical certificate is generally what has been the subject of most attention by the courts when determining whether there is a good reason for not attending. An example is the Family Channel Limited and Fatima case, which unfortunately is loose, and I do apologise for that. The fact is, in that case, counsel did attend, applied for an adjournment on the grounds of ill health. You can see that from paragraph 5. And that application was rejected, the claim struck out, but an application to set aside on the grounds of the defendant, and I'm in error, as my friend points out, it is the defendant, on the grounds of the defendant's inability to attend was upheld. There was a protracted consideration, paragraph 56, in the judgment, of whether the medical certificate was sufficient to justify her inability to come to court. At no stage did the court consider whether that was whether she had good reason for not continuing to instruct counsel who'd attended on the first day to represent her at the trial. Now, if attend in Rule 39(3) means being present or represented, then the test which has been applied by the Court of Appeal in this case and in many others would be wrong.
But she was unrepresented on the day. The case was adjourned on the first day to the second day. On the second day, she wasn't represented.
Yes. The point is only, Lord, that the test under Rule 39(3)(5)(b) is that a good reason for not attending the trial has to be demonstrated. If attending means either being in person or represented, so you are attending if you are represented but you're not there, then the court would need to consider whether the absent party in this case, in Fatima, was had good reason for not instructing someone in her to represent her instead of her attending. In effect, the courts have been applying the wrong test. And the Court of Appeal applied the wrong test in this case because they focused entirely on whether she had good reason for not being present herself. And that means not attending in accordance with 39(3)(5)(b). And there is protracted consideration in this case of the quality of medical evidence, the fact that she was suffering from anxiety, she had chest pains, and therefore had requested special measures when she attended at court. No consideration anywhere is there of whether she had a good reason for not instructing counsel in her stead to represent her at the hearing. And so as far as 5b is concerned, the court plainly considered a good reason for not attending meant not being present, i.e. not physically present as a litigant. If attending means that in 5b, the Court of Appeal assumed, then it must mean the same at 39(3)(1)(a). Well, very briefly.
You're obviously coming towards the end.
I am obviously coming towards the end. Very briefly,
nothing
preparation
else.
of notice of reasons.
Yes.
My own friend refers to that. It is perhaps unsurprising that there is an obligation to provide a written note of reasons under Rule 27(9) whenever a party doesn't attend. If represented by a layperson or an employee without legal training, a note will provide clarity to the party which may well otherwise be lacking. Given quality of representatives one would expect from a small claim, that it is entirely unsurprising that if the party is not present, that a written note would then be handed down. My own friend, very briefly in his skeleton, at paragraph 28, he refers to, he suggests that the effect of Rule 27(9) or 39(3) is to require a party to attend. Of course it doesn't. There is, it is simply, hopefully, no more than there is an obligation of a party who wants to win a case to actually to attend to give evidence when the witness statement alone is going to be insufficient. That person is not required to attend. My friend does refer to the case of paragraph 34. If I can find it. So this is my very last point. To the case of Mohammed and the judgment of Judge Hassel. The line 4 of the skeleton argument in paragraph 34, Malone and Friends says the claimant did not attend the trial and was not represented. And that is replicated in the use of words by the judge himself under on page 232.
Tab 19, yes.
And it's paragraph 3. The claimant did not attend the hearing and was not represented. I merely say that another illustration of the fact that the ordinary and natural meaning of the word attend is very difficult to avoid. In this context, attend means being present and is different from being represented in this context. If it's so difficult to avoid slippage, as it were, into and a case, and that is how the judge in that case described the background. In completion, I understand that the use of the words strikeout might create some resistance from this court. But the fact is that if the clear wording of the rule points to attend meaning being present, not being and doesn't incorporate being represented, then it is for this court to give effect to the clear wording, and the wording is clear beyond peradventure, given the what would in effect be a nonsense of syntax under Rule 11. Rule 2911. It would be an absolute nonsense. And when one is faced with a linguistic nonsense, it means that the Rule Committee, if Malone Friend is correct, would have no understanding of basic syntax. It is quite clear that they meant attend to mean in person. Much obliged.
Thank you very much, Mr. Neville. Mr. Butters, do you want to say anything in reply?
Very short reply, my lord. My learned friend spent most of his submissions explaining why, in his submission, this particular interpretation was appropriate to the small claims track regime. But he's now saying that his interpretation is also correct for CPR 3913B, and hence all trials fast multi-track. So in fact it has nothing to do with the small claims track regime at all. This is a rule that would apply to the largest of claims, and against that backdrop, understandably, my learned friend seeks to mitigate the apparent harshness of the rule, where there is, on the face of it, an unfettered discretion to strike out where the claimant is not in personal attendance, even though he's represented. And he seeks to do that by saying the discretion will only be exercised, essentially, when the case is hopeless. My lords, my lady, the court already has powers to deal with that situation. Part 3 of the CPR is not disapplied from Part 27, nor is Part 24 summary judgment. My learned friend says that would be impractical. But what we get from CPR Rule 3 first is the fact that the court has the power to make orders on its own initiative. And that's CPR 3.3.1. It's not in the bundle, I'm afraid, but it's White Book, page 124. 3.31, except where a rule or some other enactment provides otherwise, the court may exercise its powers on an application or of its own initiative. And then we have Rule 3.42a, which is the power to strike out where the statement of case discloses no reasonable grounds for bringing or defending the claim. And then we have summary judgment where the claim has no real prospect of success. There is no need for there to be this additional power to strike out that my learned friend describes. And the hazard is obvious in my submission. If the DDJ had struck this case out on the grounds it had no real prospect of success, i.e. we wouldn't here have a route of appeal in relation to the jurisdiction under 2792. We may well have had an appeal, perhaps not in this court, but at least before the circuit judge, arguing that it was wrong to strike out the claim on the basis that it had a real prospect of success for the reasons I touched on very briefly in my opening and I've set out in my skeleton argument, because the admitted facts fell within the principles established by the Supreme Court in Plevin and Paragon Personal Finance, and see the two Supreme Court cases I referred to earlier, where, although the claimant did not personally attend, the claim succeeded at first instance, and then both proceeded on appeal on different issues of law. The reality is, this rule is intended to capture a situation where no one is present, and other rules can deal with the situation that my learned friend describes. Unless I can assist you further, that's all I propose to say by way of reply.
Well, thank you both very much for your succinct and yet comprehensive submissions. We're very grateful to you and to those who sit behind you for their work in this case. We're going to reserve our judgments. In due course, in the usual way, you'll receive a draft of our judgments. Please bear in mind the purpose of that is to enable you to provide any typographical or minor factual corrections, not to re-argue the case. Please also bear in mind the rubric at the top of the judgment which prevents unauthorised disclosure, and bear in mind the consequences if there should be such disclosure. In due course, after you've supplied that, we will hand down a judgment. We will obviously at that point also make an order. It would be helpful to us if, when you're giving us your written observations on the draft judgment, you could provide us with an agreed draft of the consequential order. In the event of there being any disagreements between you, we will resolve those on paper with the assistance, if necessary, of short submissions. Thank you.
All right.